Good afternoon, everyone. So glad that you're here to join us. I will probably wait like another 2 more minutes before we start as people are joining, and then we're going to hop into our program for today. Again, welcome everyone. So glad that you're tuning in to this summer edition of DiversiTea. Today we'll be talking through the 50th anniversary of Title IX and the history of Roe versus Wade. You may be asking the question of why we're having this conversation. As you know, Converse is a learning institution and we regularly engage in complex conversations. We have chosen to bring this conversation to you all through the DiversiTea platform. As some of you may know, we invite all to join in on the conversation, making sure you have your snacks, coffee, and tea, because it's nothing better to have a good drink and a snack while you're listening to all the tea being shared. Joining us today to have this discussion is two of our very own. We have the Dean of the Converse for Women, Dr. Chandra Hopkins, who will be asking guided questions. We also have the high honor of having Stinson, Woodward, Ferguson joining us. May I take a moment and share just a glimpse of who Stinson is and why it's such an honor to have her here with us today? Stinson is of counsel to Anthony Law Firm in Spartanburg and an assistant municipal judge of the city of Greenville. Additionally, she is a licensed funeral director of services as the vice president of the corporate sustainability, previously the director of organizational development and treasurer for the J.W. Woodward Funeral Home Incorporated. The funeral home, founded by Stinson's great-grandfather in 1916, is the oldest Black family-owned business in Spartanburg, if you didn't know. She is a 2022 Fellow of the Sustainability Leadership Initiative, an innovative leadership development program for future-minded leaders in South Carolina, hosted by the Furman University Shy Institute of Sustainable Communities in partnership with Sustain South Carolina. She's a skilled and accomplished author, having been published both internationally and nationally by the American Bar Association. In 2012, she received her Master's of Laws, Environmental Law, summa cum laude from the Vermont Law School with a concentration in energy law and policy. She earned her Juris Doctorate from the University of Georgia School of Law in 2010, where she was the recipient of the Law School Public Interest Fellowship. And one of my favorite things about her is that she earned her Bachelor's of Arts in French with a minor in Business Administration, magna cum laude from the Converse University in 2007. Stinson, we are so glad to have you with us here today. You all are welcome. Will you all welcome her with me today as we start this conversation? We are about to jump into this conversation with Stinson. I love it. Yes, we are about to jump into this conversation with Stinson, led by Dr. C. Because we are only doing a 30-minute segment of DiversiTea, we will not be taking questions in the chat. With that being said, let's jump in. Dr. C, Can you take it away?
Absolutely. Thank you, Dean Stone. And thank you so much, Stinson, for joining us today. And thank you all. It's great to see so many faces. And I know that some will be watching this after. Stinson, excellent mug.
Oh, thank you.
Converse mug.
The only thing is, like, I'm left-handed, but I write with my left hand, and the way I'm the problem. But I wish there was it was on both sides, because sometimes I just end up kind of doing like this. But thank you.
That's great choreography. You're having to, yeah. Well, great. Well, we're going to jump right in, Stinson. And as Dean Stone shared, we have prepared questions today. So Stinson, could you begin with the history of Title IX in the United States? Can you give us a brief history of what this law is, what it covers, and when it was passed?
Sure. First, two things. Am I correct? Number one, am I correct that did I hear we're going for only 30 minutes?
We're going to shoot for about a half hour, but that's not to limit you, Stinson. We'll stick to our questions. And if it goes a little long, that's okay. But we just want to do a focused conversation today.
Okay, got it. That's going to be my biggest challenge, but
don't feel like you're on a stopwatch. No one's time.
I'm up for it. But anything, I believe I should and am required to say that I don't plan on sharing much of personal opinion or anything political. But to the extent it is shared, it is not the view or opinion of anyone I'm currently employed by. I'm just here for the purpose of good dialogue, and do not want anything I say to be interpreted as my personal opinion or anyone with whom I'm affiliated. So with those things said, looking to Title IX, the language first, Title IX Act of 1972, the language is: no person in the United States shall, on the basis of sex, be excluded from participation in or denied the benefits of, or be subject to discrimination under any education program or activity receiving federal aid. So that's the black letter language. In 1970, Congresswoman Edith Green, Democrat from Oregon, she was the chair of the House Special Subcommittee on Education. And that subcommittee held on a bill that Edith Green had introduced that would have amended Title VI of the Civil Rights Act of 1964. And that act prohibits discrimination on the basis of race, color, or national origin in any program or activity receiving financial assistance, not just education. So the discussions they were having in that subcommittee was to expand that to also ban sex discrimination. To little surprise, the Justice Department at that time would not support language to amend the Civil Rights Act. So they suggested that the committee concentrate or develop separate legislation that would prohibit sex discrimination in education. That was the beginning of Title IX. Putting it, to reemphasize, putting it in the Civil Rights Act would have meant that all programs or activities receiving federal assistance would have been prohibited from discriminating against women, not just in education. So Patsy Mink, Democratic legislator from Hawaii, Edith Green, whom I've mentioned, and Birch Bay, who's a male, he died in 2019, Democrat from Indiana, worked to introduce, design, and pass the amendments that are included in Title IX. Title IX is also known as the Patsy Mink Equal Opportunity in Education Act. They renamed it after one of the co-sponsors of the bill. And Patsy Mink was elected, of course, to the House of Representatives. And she was, as an Asian American, deemed the first woman of color in the House of Representatives. She served 2 terms. And Title IX actually, Title IX is called Title IX because it's actually part of a long bill of amendments, almost 150 pages. And Title IX was on about page 140 of those 150 amendments. And on one hand, it was a heck of a fight in the Senate to get that included. But on the other hand, it wasn't given that much attention at the time. Then President Nixon gave a long speech on the signing of the bill in its entirety, and his remarks focused primarily on desegregation and busing. There were no comments about sex or gender. Its impact, Title IX's impact on sports, was recognized almost immediately, although there was no mention of sports in the discussion of it. I'm happy to go on to some post-implementation or effects before we move on.
Absolutely perfect. That's our next question, Stinson.
Okay.
It is basically just because we are Converse University, could you walk us through what was the impact of Title IX on colleges and universities since 1972 to now?
Sure. More broadly speaking, there have been legal influences. The Office of Civil Rights, which is part of the Department of Education, and that is an office that enforces several federal civil rights laws, including Title IX. The Department of Education head is appointed by the president, which changes, of course, with changes in administration, and they put out guidelines about the meaning of things like discrimination on the basis of sex. Politics have changed a good bit as a result of Title IX, and it's worth noting that changes in definitions come with changes in society. At the time Title IX was enacted, the term sexual harassment didn't even exist, or I can't say it didn't exist, but it wasn't a household term, if you will. The terms non-binary and transgender were not highly recognized or understood. Ideas of gender equity have changed over time, as have the ideas of what is acceptable and what is not acceptable. So impact on colleges and universities, 4 notable areas of impact. The first would be athletics. And within that, finances and resources, what it means when you say that athletic programs should be accommodated. That can be anything from equitable coaching, locker rooms, training rooms, publicity, recruitment. This is what we often think about when we think about Title IX. And there are 3 parts to Title IX with reference to athletic programs. That's number 1, effective accommodation of student interests and abilities. Number 2, athletic financial assistance, scholarships, and 3, other program components. And that can be a laundry list of benefits to and treatment of athletes, but they all lend themselves towards equity. And sexual harassment, the second of those 4, significant expansion of guidance as to which extended coverage was extended during the Obama administration. That was reeled back during the previous administration, but if you've been keeping up with the news, I can't say if I admire you or feel sorry for you, but there have been some more announcements within the current administration to try to undo or reverse some of the rollbacks that were implemented in the previous administration. Third, rights of pregnant and parenting students. If something is done by a college for students, it should also be done if you're pregnant or parenting. That can be any special services offered for students with temporary medical conditions. Got to offer the same for pregnant students. If a school records lectures for students who miss class because they're sick, got to do the same thing for students who miss class due to pregnancy. Excuse absences. A college cannot make you take time off if you don't want to. College cannot exclude you from a special program because you're pregnant or a parent. If there's a program or activity for students who are pregnant or parents, you get to decide, that person gets to decide if they want to take part in them. A college can only make you turn in medical records if they make students with medical conditions do the same. So that would be like a doctor's note or anything like that. If they don't make students with other medical conditions submit medical papers to take part in or not take part in a class of activity, then it's illegal to make a pregnant person do so. Finally, lesbian, gay, transgender, and non-binary students. This has come more to the forefront in the past decade. The Office of Civil Rights put out a document in 2014 titled Questions and Answers on Title IX and Sexual Harassment. That greatly expanded protections and rights extended to sexual discrimination claims to include claims based on gender identity or failure to conform to traditional or stereotypical norms of femininity or masculinity. And so this was a clarification to include gender identity in sexual discrimination. This protects every student. This changed, of course, as I'd mentioned a bit earlier in the previous administration, but it looks like we may be moving back to what we saw in the administration which preceded the previous administration. Each school determines policies based on the guidelines from the Office of Civil Rights, state laws, legal cases, and their own culture. So that's reporting, education, advocacy, and mandated reporting. And so each school's specific culture is important here. So with respect to an institution like Converse, culture is important. When I was at Converse, and still now, one of my favorite things, and what I think is one of the many things that makes Converse distinctive, special, and worthwhile, is the campus culture and the institutional culture. And so that is something that is not necessary. It does not have its hands tied based on the administration. An institution can go beyond what's required or different as long as it doesn't run afoul to what's required.
Thank you so much. Yes, moving into really maybe a focused conversation on this being the 50th anniversary this summer, of course, of the passing of Title IX becoming law. Can you reflect a little bit on maybe the progress in the United States that we've seen for women and girls because of Title IX in the years since it passed?
Sure. It's a bit challenging for me to, sorry, my computer just made a noise. Hope no one else heard that. It's challenging for me to speak on that since we're dealing with multiple administrations as far as what may come to be and what was. So I'll speak generally because until the new proposed amendments, which were released by the current administration, are approved, the previous administration's version of Title IX will remain in effect. And so women did not have many opportunities, relatively speaking, prior to Title IX. We could be teachers, but not principals. We could be nurses, not so much doctors. When you get to higher education level, not seeing many women professors get tenure. If a female student became pregnant, her education generally ended at that time. There was a lot of discrimination in higher education going on. And so Title IX brought huge jumps, not only in protecting women that were already on campus, but by opening doors for women to become more involved and to be able to break those ceilings in, for example, medicine, science, or law. Now we have more women that are involved, for example, in the development and administration of healthcare, which I believe results in better outcomes, more effective outcomes for women patients. Also in the law, seeing that now we've got more women that are attorneys than prior to Title IX, we're having more women that are on the bench, that are practicing attorneys, that are legislators. So more women that are interpreting these laws. So it just creates, not necessarily that we have to have women in these roles to get good outcomes, but science has shown that we get better outcomes when we have both women, men, and people who may identify differently than traditional ideas of women and men. The more diverse representation we have, the better outcomes we get. And so I'd like to share, I made a note of a 2002 quote from Patsy Mink, one of the sponsors that I mentioned earlier of Title IX. She gave these two quotes on the 30th anniversary of Title IX. One is, there is a clear pattern of repeated attempts to weaken or undermine Title IX from the very beginning. For 30 years, we have constantly needed to be on guard to defend it. And then the second quote is, let us rededicate ourselves to the goals of dignity, equality, and opportunity for all. So regardless of the administration in place, I think we are, it may be a two steps forward, 10 steps back, depending on who you are and where you think we should be. But at least we're having these conversations, and at least we're cooking with gas at this point.
Thank you, Stinson. Okay, so let's shift our conversation now to talk about to another very significant legal ruling that impacts women in the United States. So can you give us, starting with the history, maybe a brief overview of the history of Roe versus Wade?
Sure. I'll give a brief overview of Roe v. Wade, which is from 1973. And it's impossible, in my opinion, to give an overview of Roe without giving a bit of an overview about Casey, which came in 1992 after that. So beginning with Roe v. Wade, that's a 1973 Supreme Court case. And this Roe v. Wade is the most recognizable Supreme Court decision of this generation, landmark decision, part of the Supreme Court's privacy rights revolution. It established a trimester framework wherein during the first trimester of pregnancy, states had to be pretty much hands off. Not much left to the states, but at the point of viability, which is up for debate, states could step in and regulate in quite a number of ways. So Roe expanded the right to privacy under the 14th Amendment. A woman named Norma McCorvey in Texas wanted an abortion. At the time, Texas only allowed abortions to save the life of the mother. McCorvey filed suit under the name Jane Roe to protect her privacy. The defendant was Henry Wade, district attorney in the Texas county where Roe sought the abortion. Roe, the plaintiff, argued abortion ban was unconstitutional, and she asked the court to stop Texas from enforcing that law. The federal district court, or the trial court, found the ban unconstitutional based on the statute being too vague, overbroad, and infringing on the rights under the Ninth Amendment, which includes the right to privacy. But the ban was not lifted, so Roe appealed directly to the Supreme Court. The Supreme Court held that the right to privacy does extend to a woman's right to have an abortion during the first 3 months of pregnancy, aka the first trimester. Roe has been challenged many times before this most recent case, but the court ruling of Roe remained in law until recently. Moving on to Planned Parenthood of Southeast Pennsylvania versus Casey. That's another Supreme Court case, 1992. It's an important case, in my opinion, just as important, if not more important than Roe, especially for purposes of this conversation and where we are today nationwide with this discussion. We didn't go straight from Roe in 73 to Dobbs this year. Casey severely limited Roe, and the number of state abortion restrictions enacted after Casey increased. Casey was actually almost a reversal of Roe at the time. Folks were afraid, reasonably so, that the Supreme Court was on the verge of striking down Roe in Casey, but there was some behind the scenes politicking done by Justices Stevens and Justice Souter, who were both Republican nominees, to pull Justice O'Connor and Justice Kennedy, also Republicans, on board, which turned the tide in favor of upholding Roe by a slim 5-4 margin. So I'm trying to figure out what I want to touch on and what I don't in the interest of time. Long story short, Roe was on thin ice even back in 1992. So in Casey, the Supreme Court reevaluated the constitutional protections given to women seeking abortions. It reaffirmed Roe's central holding, but disagreed on nearly every other aspect of Roe, and I think that's important. The Casey upheld the central component of Roe, but did not maintain that trimester framework. It gave us a new test, which is the undue burden test. So undue burden test, simply said, is when a state is restricting abortion, the question that should be asked is the state placing a significant obstacle in the path of the person seeking the abortion? You can analyze that lens through the purpose, or the lens of effect, the lens of purpose or the lens of effect. So the lens of purpose, I'm trying to inconvenience you. The purpose, the lens of effect being, I didn't mean to inconvenience you. Well, with the undue burden test, well, you did, whether you meant to or not, which is a good part to the undue burden test. It's not just looking to intent effect is equally important. The law that was at issue in Casey was the Pennsylvania Abortion Control Act of 1982. There were 5 restrictions on abortion providers and women. I'll go through those just quickly. Informed consent was one. Providers had to give women state published information at least 24 hours before any abortion could be performed. At least one parent had to give informed consent for a minor to have an abortion. Married women had to notify their husband and present a signed statement saying that they'd done so before they could obtain an abortion. And the act imposed record keeping and reporting requirements on abortion providers. So a few more things I think must be shared with regard to Casey before we can figure out how we got to Dobbs. Let's see, the trial court in Casey ruled that all 5 of the provisions that I just named were unconstitutional. They ruled in favor of the plaintiffs. The Third Circuit affirmed in part, reversed in part. Only the spousal notification part was deemed to be unconstitutional. The Supreme Court was presented with the question, to what extent can a state restrict abortion access? So the Supreme Court affirmed in part, reversed in part the lower court's decision and sent it back down for further proceedings. So the majority of the court in Casey affirmed Roe based on the due process clause of the 14th Amendment, which prevents states from interfering with a woman's right to abort a non-viable fetus. Remember, Roe pointed to the point of viability as the line in the sand. So the takeaways from Casey, it reaffirmed Roe's essential holdings. A woman has the right to abort a non-viable fetus without state interference. 2, states can restrict abortions after viability, with exception for pregnancies that endanger a woman's life or health. 3rd, states have a legitimate in protecting a pregnant woman's life and the life of a fetus. That interest exists from the outset of the pregnancy. The majority, with reference to the provisions of that state act, the 5 justices agreed only on that the spousal notification was unconstitutional. Beyond that, the court was divided.
Thank you so much, Stinson. And I also realize that we're asking you enormously complex questions. And then so don't feel like you're under a kind of stopwatch, but if you're able, when we think about this conversation, 50 years ago was the passing of Title IX. This summer, 49 years later, Roe versus Wade is overturned by the US Supreme Court on June 24th. So can you walk us through the legal process in this most recent ruling? You just did a fabulous job really showing us it's not a straight shot from Roe versus Wade to Dobbs by really explaining the legal process behind Casey. So if you could give us maybe the legal process behind this most recent ruling on June 24th.
Sure. So the case name is Dobbs v. Jackson Women's Health, Jackson, Mississippi, Jackson Women's Health Organization. So in Dobbs, that organization, an abortion provider, and one of its doctors brought a federal court case challenging a Mississippi state law that prohibited abortion after 15 weeks of gestation. The plaintiffs in that case argued that the law unconstitutionally infringed on a woman's right to have an abortion based on Roe and based on Casey. So the federal district trial court ruled in favor of the plaintiffs and permanently enjoined the law. The Fifth Judicial Circuit, which is a circuit the court that you appeal to if you're not happy with what you get from either party can appeal. The Fifth Judicial Circuit affirmed. So the Supreme Court, it was appealed again, and you asked the Supreme Court to grant a writ of certiorari, and the Supreme Court did. They agreed to hear the case. So in summary, Dobbs defederalized the issue of abortion access and abortion rights. It looked through a 14th Amendment the 14th Amendment's Equal Protection Clause lens of liberty, which prohibits the states from depriving any person of life, liberty, or property without due process of law. And due process has been used by the Supreme Court to strike down state legislation that restricts personal liberties and interests not explicitly mentioned in the Constitution. So in Dobbs, for the first time since Roe, the right to choose to have an abortion is no longer a protected fundamental right or a liberty interest under the meaning of that term liberty. So states are pretty much free to restrict however they want or don't want. This is going to give us, and is already in the process of giving us, a patchwork system wherein some states are permissive and do things to bolster access, and in other states there will be additional restrictions and fights ahead with regard to what states can and can't do. Federal courts' roles going forward. In Dobbs, it was said because this isn't a fundamental right, anytime this might come before a federal court going forward, it's going to be given rational review. Any law, state law that's being challenged that goes forward will be viewed through a lens of rational review, which is the most deferential form of review a government can face, aka the lowest hurdle, the lowest level of scrutiny. Usually when rational basis is the standard, the government wins because they can come up with a legitimate interest, and the regulation is the court's going to find it to be rationally related. So it's not an entirely hands-off approach, but more or less in effect it is. And the court in Dobbs provided a laundry list of all legitimate interests that a court can have, may have in regulating, state may have rather, in regulating abortion, to provide a few examples: respecting and preserving unborn life, the integrity of the medical profession, safety of a pregnant person, mitigating fetal pain, preventing discrimination against the unborn. So under this permissive rational basis standard, these things aren't going to get struck down, not at least in federal court. By giving this laundry list, the court also basically provided a how-to to states looking to craft regulations, how to survive this rational basis standard if challenged. The court in Dobbs discusses stare decisis, which means the court's going to follow, a court is going to follow its own precedent, follow previously thought out opinions. And so the Dobbs court does discuss stare decisis a lot. It promotes judicial efficiency, upholds the integrity of the judicial system, promotes even-handedness. But the court then says, yes, we think stare decisis is important for the reasons above, but it's not a straitjacket, and there are certain circumstances where it might be appropriate to strike down past precedent. They found that this was one of those, they determined that this was one of those situations. And so with regard to stare decisis, they looked to, Dobbs provided 5 factors to consider. Number 1, the nature of an error in past precedent that goes to the issue of legal fault in past opinion. What did the court do wrong? That's what a court's going to discuss when trying to determine whether or not they're going to overturn a past precedent. Number 2, what's the quality of the reasoning in the past precedent? That relates to number 1. Number 3, how workable is the past precedent? I'm sorry, I need a nap, admittedly. So I'm capable of speaking clearly, but at this moment in time, y'all be patient with me.
We need tea. I think we all need tea.
Amen, at the very least. So the court talks about number 3, how workable is the past precedent? And so the court talks about, with regard to that undue burden test that was established in Casey, when you're looking to abortion, the court talked in Dobbs about how that's not workable. And admittedly, there are Supreme Court cases where the court applies the undue standard in very different ways. Number 4, how has this precedent negatively affected other areas of law? The court talks about things that it itself has done that are inconsistent with what black letter law rules the court has previously laid down. For example, a Texas law that allows third parties to sue someone they think is trying to access an abortion. The court allowed that lawsuit to go forward this year. The Dobbs court cites this as a reason as to why Roe has interfered with areas of well-settled law. I'll leave further discussion of that to you and your personal and private groups as to what you might think of that, that reasoning. I think it could be argued to be a bit circular. And number 5, this is the most important factor, and this is something the Casey court spent the most time on in its 1992 decision, a reliance interest. In 1992, the case said that Casey court said, we won't strike down Roe because women rely on this access. In Dobbs, the court reeled that in, and they said this kind of reliance is intangible. How can you prove that kind of reliance? Who relies on a pregnancy that may be unexpected, or that they may end up wanting to terminate down the line? Anyway, for these reasons, the Dobbs court said that stare decisis, aka us needing to stick to precedent, does not apply here. So the majority said that abortion should be left to the voters of each state, and this is an ongoing current that we're seeing in constitutional law.
That's a fabulous segue into our conversation. Really, if you could just take us to South Carolina. So you are our neighbor in Greenville. You're a resident of South Carolina. You're also have been hugely active in really wide-ranging service on numerous boards. You're an attorney. You're also a municipal judge now. So can you tell us what this means, Roe versus Wade being struck down? What does it mean for South Carolina? What in this state has it created?
Sure. So here in South Carolina, pre-Dobbs, so back to 2020, let's just go back to January 2020 before COVID, just to be in a happy place before COVID existed, or before COVID was prevalent, at least. I don't know if it existed or not at that point. So pre-Dobbs, in 2020, South Carolina law prohibited abortions after 20 weeks of pregnancy unless certain medical exceptions were met. About 50% of the states are expected to, this is going back beyond South Carolina, but just FYI, about 50% of our states are expected to limit or completely ban abortion, and South Carolina is in that category. Earlier this month, our state legislature kicked off the process to do so by holding a public hearing by a special state House of Representatives committee. So with Dobbs came a clear path for South Carolina's current heartbeat law to become effective. What is the South Carolina heartbeat law? Full name of the legislation is the Fetal Heartbeat and Protection from Abortion Act. This was in limbo after being passed by the South Carolina legislature during its last session, and it was signed into law by the governor in February of last year. It did not immediately become law because a temporary restraining order followed by a preliminary injunction was granted by federal judge Mary Geiger Lewis in March 2021 as a result of motions filed by Planned Parenthood and others against the South Carolina Attorney General. They filed these motions before the governor had even signed the legislation, seeking to temporarily block it from becoming effect. So with that injunction in place, South Carolina's previous abortion laws, which I mentioned, looking back to 2020, remain the law, and the case would have had to be appealed to a higher court for review. Other similar bills from other states, about 12, had passed similar laws. They were all tied up in lawsuits, and they'd have to go in front of a federal judge, judges around the country before anything would be able to change. But last month, following the Supreme Court, the highest court in the land's decision, ruling that the federal judge, Judge Lewis, she ruled that the South Carolina heartbeat law could immediately become effective. And so the regular legislative session for our state legislators ended in May, but Republican legislators, I've heard, are in favor of reconvening potentially for a special session in light of this Dobbs decision. And so this bill in the last session was intentionally prioritized by particular legislators to be passed and signed by the governor at the time when it was. The final vote in the House and the Senate, it was proposed in the Senate, so it had to pass 3 readings in the Senate before it could go down to the House, 3 readings in the House, and then it goes to the governor for his signature. But although that the votes in both houses on this bill were largely along party lines, there were some crossover votes. In other words, in the House of Representatives, there was a Democrat. Democrats are traditionally, at this point in American history, will vote for choices, the option to have an abortion. We had one Democrat that voted in the House in favor of heartbeat law, and we had 2 Republicans in the House that voted against it. In the Senate, we had 3 Democrats that voted in favor of it, and in the House, we had 1 Republican that voted against it. So without regard to how I or anybody else may feel about the law, I always like to see votes that aren't strictly along party lines. I think it means we're thinking, which is encouraging for me. And so the Heartbeat Act in South Carolina is an example of a trigger law, and it prohibits most, and trigger in the sense that it fired off, it was ready to go as soon as the Supreme Court gave the green light, which Dobbs did. And to go into the substance of the law a little bit, it prohibits most, but not all abortions when a fetal heartbeat is detected, which is roughly 6 weeks into a pregnancy. The South Carolina law requires doctors to conduct an ultrasound to detect a fetal heartbeat if they think the woman is 8 or more weeks pregnant. The South Carolina law also contains a provision stating that doctors will be fined $10,000 and can face up to 2 years in prison if they fail to check for a heartbeat, or if they perform an ultrasound, detect a heartbeat, but proceed with an abortion anyway, assuming none of the carve-outs, none of the exceptions exist. The Act notably contains no provisions outlining penalties for women seeking abortions, and it does contain exceptions for these weak requirements when a woman's life is in danger, or if the pregnancy is the result of rape or incest. So if a heartbeat is found, an abortion can only be legally performed if the woman's life is in danger, or if the pregnancy is found to be the result of rape or incest. There's some potential legal challenges that could be raised. I won't necessarily go into that. But for South Carolina, some are anticipating a step up from this heartbeat law that is now in effect, which would be a complete ban. Others anticipate a ban, but with exceptions that are aligned with the exceptions in the current heartbeat law. Not my personal opinion, but my opinion just from someone who may know a little bit about the law and how legislators act. I think it would be challenging to get a complete ban with no exceptions passed here, especially in light of what I just mentioned about having some of those crossover votes. At most, I would say we may have a ban, a complete ban with those same carve-outs for rape, incest, life of the mother in place, but lawsuits will most definitely follow. We've got a Republican governor right now, a majority Republican state legislature, but we lack the 2/3 majority in both the House and the Senate that would be needed to overcome the legislative process or a veto if a Democrat wins the governor's election this fall. Time will tell on that. And some Republican legislators have stated that they oppose a complete ban on abortion, especially with those carve-outs.
Thank you so much, Stinson. Really appreciate you giving us this foundational information and walking us through the legal complexity of both of these monumental decisions. Thank you. Thank you. I will now turn it over to Dean Stone, who will wrap us up. Thank you again, Stinson.
Sure.
Thank you. I appreciate the fact that you just spilled a lot of tea for us and just sharing that information and just kept it factual. Like, here are the facts. This is what we're doing, and this is what's happening, and make it even local and breaking some of those things down. So thank you for your time. Thank you for all those who leaned in to listen. And please tune in, because we'll have another DiversiTea soon, starting in the fall. Thank you again so much, Stinson, for coming and just sharing with us some of your expertise on law and policy. We really do appreciate you. Thank you, Dr. Hopkins from the Women's College, to share and just start the discussion by asking some questions, some guided questions. So we do appreciate you too. You all have a lovely afternoon. If you have questions or follow-up, please feel free to email any of us. Thank you so much.
Bye, y'all. Thanks.